We might have problems with it. But if we get that data and we get something published in a peer-reviewed journal, sky's the limit. But what are some of the other take-home messages for all the things that I've talked to you about? So things that you, when you go out to advertise your services in the Starting Strength program, what are the things that you can take from this? Number one, a specific measurable claim you make can't be false. You have to have support for it. Not only can it not be false, you actually have to, you can't just throw things out there. You actually have to have some support for it. Remember, commercial puffery and boasting is okay. So instead of making a specific statement that you can actually verify or disprove, I'm sure there's a way, if you're creative enough, that you can think of a way to sell your services in a way that looks like advertising, right? Something that a reasonable consumer isn't going to assume you're making a statement of fact about. A fairly obvious one, and I've tried to emphasize it a couple times, don't make health claims unless you have a study to show it and the specific claim you're making. What Dr. Sullivan was saying is, there are many different studies that show that resistance training is, can I say, correlated with good health outcomes? Yeah, correlated with good health outcomes. And those studies run the gamut. They can be completely ridiculous things like, our Bosu ball, plastic weights, that. Or it could actually be true formal resistance training, like something more like we do, like actually a squat or a deadlift or a leg press or something that's a little bit closer to a full body movement. And no matter what study you look at, they all show basically the same thing. So as a result, if we are a resistance training program, we could make the claim that our resistance training program will improve your health. And actually, I did misspeak. I think when I say health outcomes, I mean trying to compare the program to other types of health outcomes, kind of like the second example I put up here. The question over here is, so with obesity now classified as a medical disorder or reclassified as a medical disorder, does that create a problem if we start making claims about how this, is it fair to say, the question is, can we start making claims about whether you can help your obesity with Starting Strength? Rip asked a very similar question last year, actually, with respect to dietetics. If I try to help somebody lose weight, am I trying to treat a medical condition of obesity? I think I'm going to answer the question the same way I did last year. You're not trying to cure obesity, you're trying to help somebody lose weight. You're trying to make a fat person less fat. Whether it's obese or not, I don't really know. All I know is if you do a certain program and you take in fewer calories than you expend, you're going to lose weight. And I think that's as far as we really should go. I don't think we need to go further than that.
I think that's smart. But I can tell you one of the first things I say to all of my prospective clients is, this is not a weight loss program. And I just take all that shit right off the board. I mean, I just take it out of play. That's one of the first things I tell people, this is not a weight loss program.
Perhaps if you avoid using the term obesity.
Right.
Yeah.
Obesity is a medical term.
Right.
And it specifically describes a condition.
I prefer the term fat.
Yeah, I think if you're a fat guy, right? You're not morbidly obese, because that's a medical diagnosis. You're a fat guy.
Right.
Is just an observation. Right?
I'm in complete agreement. And yeah, I mean, I don't think our program has results that people can see. I don't think we need to oversell it. It sells itself, right? I mean, we had Bo yesterday talk about how he now has, 150 members, something like that, who actually are ambassadors of the program solely because they have seen the results for them. We don't need to oversell this stuff, so let's not do it. Let's let the results speak for themselves. Now, last year I paid a homage to Steve Jobs at the end, and I'm actually going to do the same thing this year. One more thing. Last year I talked to you about licensure. I talked about the threat that faces our industry. And we have some updates this year. So the first one is what has actually happened in 2015. Well, number one, Representative Robert Fennell offered another bill in Massachusetts. He offered one in 2013 and he co-sponsored one in 2011 to regulate the personal training profession and to require licensure. It is a horribly written bill. It is so bad that the committee won't even look at it because it doesn't even have an enforcement mechanism in it. It literally says personal trainers will be licensed. That's about it. So it's not a huge threat, it's not going to go anywhere, but the point is we are seeing a full court press on Massachusetts legislators to try to do this, and there's a reason why it's considered a significant threat by watchers who look at this. Now, I also talked to you last year about DC, and in particular DC Code Section 2-1209-0.08. This provision was an authorizing statute to require licensure of the personal training profession. The Board of Physical Therapy in DC would actually draft the regulations. Those regulations were supposed to be released on September 22nd of this past year. You probably noticed that they weren't, especially if you follow the forum. Why is that? Well, Representative Jack Evans in the DC City Council offered a bill to repeal this statute. And 6 members co-sponsored it, which is already a majority of DC City Council. Now, we're not out of the woods yet because that hasn't actually passed. They haven't put it up for a vote yet. But as a practical matter, it looks like it's going to pass. It looks like we dodged a bullet here. So it looks like the authorizing statute for DC is going to be repealed and we won't have to worry about the regulations. I think that's why the regulations haven't been released for comment. Because I think they realize there's a high likelihood that it's going to that they're going to be repealed. But just because this year is not a problem for us doesn't mean that we shouldn't be worried. Since 2010, these are all the legislative initiatives for personal training licensure: Florida, Georgia, Maryland, Massachusetts, and New Jersey. And a lot of them have multiple attempts. Maryland's the only one that just tried it once. The point is, there is an attack on our industry. There is an effort to regulate it. There is an effort to require licensure, and this effort is not going to go away. And so we need to be awake, and we need to know, and we need to watch what's going on in our own particular states very closely. Otherwise, DC, we got lucky. We were able to put the genie back in the bottle in DC. That's very rare. Usually when a statute passes, you're pretty much done. But it looks like we might have dodged a bullet there, and we actually have to thank our friends at CrossFit for that, because they were the ones who really did the full court press on it. So some of you may know, and maybe some of you read it, that I wrote an article about why these things are problematic. It is a fairly in-depth article. I believe it's 12 single-space pages. I would refer you to that, but I want to give you all sort of a working knowledge of how you talk to people about this issue. Because if you ask people, do they want to see personal training regulated? Do they want licensure? A lot of them will say, if they don't think about it, well, sure, that makes sense. We don't want people who are incompetent trying to train other people to do complicated movements and possibly injure them. You know, and you see quotes in these news articles all the time about it. People say, yeah, that makes sense. We have the ability to change those minds, to change the minds of legislators, to change the mind of skeptical friends or people in the industry who might have a different view than us about this. So I'd like to talk about the problems with licensure laws. I want to actually go over a quick 5-minute spiel that you can give to explain why these are a problem. Number one, licensure is not necessary for personal training. Does anybody know the rate of injury of people in personal training services? No, nobody does, because nobody's ever done the study. There's actually no data that shows what the injury rate is. The closest thing we have are the injury rates of people who engage in resistance training. And the studies show that resistance training is one of the least dangerous physical activities in which one can engage. right? The study that I cite in my article, the one that I know Rip has cited a few times on the forum, shows an injury rate of 0.0037 injuries per 100 participation hours. That's, by contrast, Zumba is 1 injury out of 100 participation hours. Zumba is more than 200 times dangerous than resistance training. Zumba is more than 200 times. One injury per 100 participation hours versus 0.0037. Yeah, it was actually in a exercise textbook that I cite in my article. So yeah, I actually was shocked. I was shocked when I saw it. I just wanted to look at it. Okay, problem number 2. It won't make personal training safer. If somebody is injured in a personal training session, why is it most often going to occur? There are freak accidents, and we can't help that sometimes. But why most often will it occur? Because they did something wrong. Right? They let their back flex or something along those lines, right, when they have a load on. Well, but the thing is, of the personal training certifications that would be recognized in these licensure laws, none of them require a demonstration of an ability to coach someone in real time. In fact, I found through internet searching over 140 different personal training certifications in the United States. Very few of them actually require a demonstrated ability to coach someone in real time, to coach a movement correctly. We're one of the few organizations that does. I mean, for us, you actually fail the platform exam if you can't get your trainee to squat properly. It's one of the reasons why I think we have the best certification in the industry, and that is puffery for the record for the FTC if they watch this. But also, we also got some help from the Obama administration. In July of 2015, the White House released a report that found, based on the data, that professional licensure in most circumstances does not improve safety and it does not improve quality. The only studies they had that showed it were for dentists. We are not dentists. So there really is no evidence that even if there were anecdotal problems with personal training, that licensure would solve it. 3, the laws are patently overbroad. It's very difficult to define what personal training is, right? How do you define what a personal trainer is? It's a little bit easier, I think, for things like medicine or law. It's still a little bit vague from time to time in those professions, but personal training is a little different. And if you look at the definitions of these personal training licensures, it is broad enough to cover things like karate instructors, like volunteer football coaches who watch kids in the weight room, a whole slew of things and activities that were probably not intended. Now, I suppose the enforcing agencies could say, well, we are going to exempt those, but the point is we don't know, because it's ultimately their arbitrary decision. So we may open up a Pandora's box here that could affect not only people who want to get personal training, but even people who want to be coached in, for example, track. 4th, the law inherently limits choice. I told you originally that there are 140 personal training certifications in the United States. The most liberal of these licensure proposals would require a certification that is accredited by what's called the National Council of Certifying Agencies, NCCA. They're basically a certifying agency that says this particular certification is accredited because it fulfills certain procedures that we deem important. There are only 16 personal training certifications that are accredited by the NCCA. We are not one of them. USA Track and Field is not one of them. USA Weightlifting is not one of them. CrossFit is not one of them. So what happens if we do this is, let's say that somebody wanted to get a track coach. They wanted somebody certified by USA Track and Field to work on their running. They can't legally do it. It's illegal. In fact, there's criminal liability. What if somebody wants to work on a primarily strength-based program? they can't come to us because the law says they can't do it. So if it's unnecessary and won't make personal training safer, why would we want to limit the choice of consumers? The last one, though, is the most nefarious, and this is the one that is usually not talked about. Whenever we talk about licensure laws, everybody talks about the licensure part of it, that you need to have a license, you might have to have a 4-year degree, something like that. Basically what I'll call the barriers to get into the profession. That's usually what's discussed. What isn't discussed is that most of these proposals require establishment of a standard of practice. It actually commands the enforcing body to create a standard of practice. And this should scare everyone in this room. It should scare anybody watching this video. It should scare anyone, even if they have an NCCA accredited certification. Let me illustrate. This is the definition of a squat as we use it. The crease of the hip, B, is below the top of the patella, A. That is also how that's also how a lot of the industry defines a squat. If you go to a powerlifting competition that's reputable, this is what they're going to expect out of you. This is what a lot of people require. This is what, frankly, a lot of bodybuilders require. Some of the bodybuilders I used to follow were all about their below parallel squats. Here's what the American College of Sports Medicine defines as a squat. They do not recommend going lower than that. Now, the ACSM is an NCCA accredited certification. A lot of these proposals guarantee them and their compatriots seats on the enforcing bodies. It is very possible that if they are charged with creating a standard of practice, that on the right could become the standard of practice, which means that if you tell somebody to do something on the left, you are in violation of a standard of practice. And it's not just defining the squat. What about resistance training for teenagers? Right? Every time you have a prodigy weightlifter, there's always some doctor who goes on TV and says, well, this might interfere with their growth plates and it might keep them short, even though there's no medical evidence that supports that, but it's sort of become an old wives' tale. But Dr. Sullivan says the Valsalva maneuver. You actually have some folks who say you might have a stroke if you Valsalva, even though there's no evidence to support it. But here's the problem. When you give wide-ranging ability to create standards of practice, that could happen. We don't know what those standards will look like. They could be innocuous. They could be things like, make sure that you get a medical history before you train somebody. You should be doing that anyway. You know, make sure that you evaluate injuries. But it could be things like squatting is contraindicated for insert categories of people. People who we normally squat. People like maybe Dr. Sullivan's clients. Maybe like my mother who's 67. You know, squats below parallel. So the bottom line is, this is a scary proposition. But it is up to us. We have the power to persuade other people. The reality is, in DC, better reasoning has won. We actually took on big fitness and won. Now, we'll never know how much Ripa and my articles factored into that versus CrossFit. But the fact is, we're making a push to spread the word as to the problems with this stuff. We have an ability to do it. And so I would implore you to go forth and do that. Yeah.
That's great stuff. I mean, basically, you gave us an elevator pitch there. It's unnecessary. It won't make training safer. It goes overboard. It inherently limits consumer choice. It creates unnecessary and limiting standards of practice. You forgot to mention the cost of training. Consumers will hear that.
Yeah. Well, and that's
I'm going to get more expensive if you make me, get a license.
And that's a great point Dr. Sullivan makes too. Not only are these 5 things problematic, but almost certainly the cost of personal training is going to go up. Because if nothing else, there are fewer participants in the market, and those that do participate in the market have to jump through more hoops. So yeah, it's very possible that the that the cost is going to go up. And in fact, the White House study from July of 2015 said in most cases it does go up, sometimes by as much as 25%. So I am at this point going to open up the floor for questions. It can be about absolutely anything. It doesn't have to be what I talked about. The only thing I would say is I don't know your specific legal case. So, you know, if your aunt got a divorce and you want to know if she's going to be able to keep the kids or not, I have no idea. Sorry. And I'm not going to guess on that anyway. But anything, I'm happy to discuss anything. It can be about this. It can be about any other legal topic that you want. I'll throw it open for about, 10 minutes, something like that? 5-10 minutes? Yeah. What's the best way to keep track of proposed legislation? This is really difficult to do, I've found. It's extremely difficult, and I do this for a living. There is a group, and I actually, the name is escaping me, but it's something like the International Gymnasium Racquetball and Tennis Association or something like that. But I'm sorry? Yes, the IHRSA, they actually do monitor this stuff fairly closely. And in fact, they have sort of their threat list. They have, major threats, minor threats, and then places they're watching as well. And so I would say that's one website to do. I am following it, and I try to post updates to the forum whenever things come up. And I know CrossFit watches this stuff really closely too, because their business model is usually the one threatened more than anybody else's. So there are a lot of third-party sources that watch this stuff closely, and I'd say just, you may have to Google sometimes just to see. But yeah, it's very frustratingly difficult to follow this stuff. Yeah, the question is there a way to create a business model so that if one of these things came to pass, that you could basically not be liable for personal training, that you basically push that part of the business off to the side, I guess. I actually haven't thought about it. I'm sure there's a way to structure it, but the problem is you're not going to be able to be involved in it. And I think that sort of defeats the purpose of what we want to do as an organization, right? I mean, we're a very hands-on group. I mean, even when we have open workout and don't have any plates because 60 people are deadlifting and squatting at the same time, but even when we do that, people are still coaching each other. It's just in our nature. So I think there's probably a way to do it where you just collect the revenue and maybe have people who are certified do it. But it's going to be very difficult to do it and have any sort of control over it, I think. Yeah, so question is, are there any specific provisions you have to have if you train out of your home? And I don't want to give legal advice because I can get in trouble doing that. Here's what I will say. When you are training out of your home as opposed to a gym, usually when you train people in a gym, it's as an independent contractor, which means that you don't own or maintain the equipment. So one of the issues you face in a home is you actually have control over the space. So it's something you need to account for in the waiver. The other thing you need to account for is for them to get to your gym, odds are they have to go through rooms that are not the gym, right? Like usually they'll have to walk in like the front door and go to the garage or something along those lines. You need to make sure that your waiver covers all the areas of the house so that, when I talked about fairly covering the injury at issue, if they trip on the stairs going into the door, that wouldn't be covered by a waiver that talks about, that either talks about training in the gym or just omits it entirely. A court may say, well, it's, the purpose of the waiver was to cover injuries from training, not to cover injuries from just slip and falls in a home. I would also look up premises liability issues in your state because they would be considered a business invitee, and there are certain responsibilities you have. Generally, it's pretty consistent in a state that you just have to warn them about defects in the house, like if there's something that they may not see, or if there's water on the floor or something, a low rafter, you might have to warn them about that because you own the premises. But yeah, I mean, I would also basically just err on the side of over-warning and err on the side of over-inclusion.
Electronic waivers and electronic signature capture, is that acceptable?
Electronic waivers are fine. Anything that is intended as a signature counts as a signature. So, I mean, literally, if they if they prick their finger and push on it, on the paper, that counts. You know, that's if it is intended as a signature. So yeah, electronic is fine, as long as you have a record to show that they actually did it. Make sure you have that record. Nothing about the Supreme Court same-sex marriage decision, huh? Interesting. Okay, well, seeing no further questions, thank you very much for your time and attention. And I think Mr. Jones is next.